Title records and protection. Title records and protection. Luckily, this is a short chapter, just a continuance of yesterday's chapter. So why do we need title records? Or why do we record something into public records? Say louder. To give notice of the world to the world of what? Of real estate, that's it. Of anything. Almost anything can be recorded into public records, right? But the main idea here, when you record something into public records, is for protection. Is to show that you have a claim or a stake in that property. Okay? To show ownership, to change ownership, to be acknowledged, absolutely. Now the thing is, anyone can access property records. Did you guys know that? If I know you own a home, I can find out if you've been paying your mortgage or not. If there's a lis pendens or a lawsuit against it, we talked about lis pendens already, then I know that you're losing your home. That's how most investors work. They go and search public records for properties that are in default. Okay, it is a public record. Now, documents, claims, and other property ownership details are in the land records. A buyer must be sure that the seller has good title to the property, and a buyer or lender must know if the property has liens or other encumbrances. I know it's been a long time, but what is an encumbrance? A hold? Okay.
A lien is.
A lien is an encumbrance. Claim, clouds, burden, perfect. Restriction, absolutely. So the word encumbrance means a cloud on the title or a restriction on the title. It could be a claim or a benefit or interest that somebody has on the property. Negative, yes. All right. Now, an attorney or title company searches public records to ensure a good title. A real estate professional should know what the public record and the search reveal. So our job is not to pull public records, but once they're pulled, we should be able to look at it and say, hey, this is what we see, this is our opinion, but it's not a legal opinion. Okay, we can give our opinion, but we have to be very clear. You should consult a lawyer for this or that, whatever purpose. Okay. Now, public records contain detailed information about each piece of land or parcel. These mean the same. Located in a particular city or county. These records establish ownership, notify of encumbrances, and priority of liens, and its purpose is to protect the interests of landowners, taxing bodies, creditors, and the public. Its purpose is to protect the interests of landowners, taxing bodies, creditors, and the public. Real estate recording includes any documents that affect the title to the property, like deeds and mortgages. Although not recorded or listed in land records, taxes, judgments, probate, and marriage records may also impact the property title. We talked about this yesterday, right? When we talk about dower and courtesy, homestead, right? A spouse could take over the title of the property somehow, right? So these are not recorded. So we don't know if a person is married, right? Unless we ask. When the title company does a title search, they usually find that stuff out, because they go through additional records that are not land records. Depending on the property's jurisdiction, public records can be kept or maintained by a recorder of deeds, county clerks, county treasurers, city clerks, collectors, or even clerks of the courts. So that depends on the municipality. Even here in Jersey, we have some places that have registrars of deeds, others are county clerks that record the deeds. Now, notice, what does this word mean? notice. What does the word notice mean? An announcement. Okay. Yep. An announcement. Letting know. Thank you, Nika. What else? An announcement. Letting know. Anything else? Could it mean anything else? Attention. Yes. Warning. This is what I want you to think about. Warning. In fact, when it comes to real estate, this is based on caveat emptor, which means buyer beware. Warning. There's all this stuff against the property. Do the title search so you can find everything that's against the property. Okay. So notice is a warning. It's a heads up. Listen, this is happening. So anyone with real estate interest can give notice of their interest to the public. So for instance, if I did some work on your house and you did not pay me, what can I do? I can tell everyone it didn't pay. How do I do that? Instagram and Facebook.
How many people make a record of it?
Yeah, but that's not going to be enough to stand on when we go to court.
What, a public record?
Has to be a public record. And then she's going to go like, oh, but Instagram is public. Not enough for land records. Okay. Ashley says Facebook groups, they come strong. I know. I know. Jeez. Tough. Anyway, so we're going to put a lien against the property. I'm going to file a lawsuit against you, right? When I file that lawsuit, I'm going to then get what's called a lis pendens, which is a notice filed against the property saying, hey, there's a litigation pending. There's a lawsuit pending, right? That's what we do. If it was based on landscaping or some type of work that I did, it's called mechanics lien or construction lien. Okay. Now, notice can be either constructive or actual. Let's go with constructive notice first. Constructive notice. Constructive notice means that information is available. Constructive notice means that information is available. Okay. So when I put something into public records, do I have to then share with everybody? No, that's it. It's in public records. So that means constructive notice. Whoever has an interest in the property has to search public records to find out what's there. Okay. The moment we put it there, it's called constructive notice. As an example, except for chapter 8, but every chapter has been popping up on your student portal every day, right? That means constructive notice. If you didn't go to your student portal, that's your problem. And that's how the world sees it when it comes to real estate. Oh, you didn't know that there was a lawsuit against the property? That's your problem. Oh, you didn't know taxes weren't paid and there's a tax lien against the property? That's your problem. Oh, you didn't know that it's in active foreclosure? That's your problem. Because all these are filed, they're there. The fact that you didn't search, that's your problem. Okay? Once you search, yep, it's considered actual notice. Because you inspected the property, so now you actually know the information. So constructive notice, information is there. Okay. Actual notice is actually having knowledge of something because you did your part, you did your research. Now, question. Can I say I did not know? Say it louder.
You can say that, but it's not gonna matter.
It's not gonna matter because it was there. Okay? That's the key. Constructive notice, it's available. Actual notice, I actually know. Can I say I forgot? It's not gonna matter, but I can say it. Absolutely. We can say whatever we want, always. The question is, will it matter? It's like my kids when they're pouting and doing those tantrums. I'm like, not gonna, it's not gonna change anything. Anyway, recording. So recording means making documents publicly available. State laws govern document recording and requires that any document affecting an estate, right, title, or interest in land must be recorded in the county or town in some states where the land is located. This makes it easy for the interested party to find other parties' interests that might affect their own. Okay, real quick. I just read that we're gonna find other parties' interests that might affect our own. So you guys remember in legal descriptions, there was a property there that said block 1191 and lot 114. The property was 153 Murray Street. That was my property. Okay. I purchased that property from somebody that was in foreclosure. I resolved the issues, whatnot, right? But when I went to sell that property, I couldn't sell. Why? Because there was something in public records that I did not know. So one of the things that I advise clients nowadays, do a preliminary title search right before you sell. Because it's like pulling your credit. Sometimes you have stuff there that's not yours. I had a lien of, I forgot if it was $16,000 or $17,000 against my property, but it was because of the previous owner. They didn't resolve it. And this company tried out of the blue, hey, let's see if nobody notices, files a lien against my property. Now, for me, it was a setback because I went 4 months waiting for it to be resolved. Title company got involved, everybody, like it was a mess. And I couldn't sell right away. But that's what I'm saying. We record stuff to file our position. If I did not have a deed with my name, saying that it transferred ownership, if I did not have a deed with my name and title insurance, which we'll talk about, if I did not have that, I would have to pay $16,000 that did not belong to me. It's against my property. Do you want to sell? Yes or no? Then you have to pay. You guys understand?
If you didn't have title insurance, it only had you to be, I mean, you could prove that.
Yeah, that's from a previous act. It had nothing to do, but without insurance, it's like having a car. You get into a car accident, right? You're gonna have to pay, right? Depending if it's your fault or not.
Yeah.
But an insurance company, they don't care. They'll look at you. I'll give you an example. 2 years ago, I was getting out of my parking space at CVS down here on Chestnut Street, and some lady just decided to, back, stops right behind me, out of the blue. I'm already backing out, and I'm coming from the handicap. I had it was my right before my first surgery. I already had the handicap sign and everything. Slowly, I didn't see this lady at all. My car did not beep at all. All I know is, boom. I'm like, oh, what now? Right? Guess what? Both of us have to pay. They attributed 50-50 fault, even though she's the one that stopped right behind me when there was not a parking space. And I even took a picture, like, Google Earth, right? I drew, this is not a place to stop. She was not passing by, she was stopped. They don't care, right? So if I didn't have insurance, I would have paid $3,500 to fix her 2 doors. You know what I'm saying? Because I had insurance, I only paid, I think it's $250, and I got stuck with an additional $100 every single month on my bill. Insurance went up. But that's what insurance is for. So in this case, if I did not have title insurance, I could have been responsible for $16,000, or I would have to fight it saying, hey, listen,
It wasn't me.
it wasn't me, right? But then I have the expense of the attorneys, I have the time frame that this is gonna take forever. Then I also have a buyer that wants to buy that can sue me because we're in the contract and now there's this issue going on. You see what I'm saying?
So is
So-
title insurance like a one-time fee when you're buying?
Oh, I'm gonna address that
Okay.
towards the end of this chapter. Um. Alexander said preliminary what? Preliminary title search. Preliminary meaning you just do a title search before you even put it on the market. Michelle's like, isn't it required when you get a mortgage to get a preliminary title search? Well, yeah, when you get the mortgage, but I'm the seller, not the buyer. In my scenario, I was a seller, so I should have checked the title before I listed the property. That's what I was saying. Yep. And as far as can you take, I think I already addressed that. All right, cool. So by recording an interest or claim, priority is established, usually first in time, first in line, or as commonly known, first come, first served. So if I record today and you record tomorrow, it doesn't matter who wrote it first. What matters is the recording. Okay, the recording date puts you first in time. If it puts you first in time, you're first in line. Okay, it's like going to the hospital. You got a big cut on your head, the other person just has a stomach ache, but if my number was first, I'm going in first. Right? First in line, first in time, first in line. You do it in the process of buying, or should we always offer? We don't do title insurance, guys. The title company will issue that. We do recommend clients to get title insurance. Superior liens like taxes and special assessments. Stephen, no, not in this case, right here. Superior liens like taxes. This is property taxes, by the way. Property taxes and special assessments are exempt and supersede the recording timeline. So the IRS, Stephen, the IRS in this scenario is not a superior lien. Property taxes are first, then everything else. Okay, and it goes by timeline.
What is special assessments?
We'll talk about that when we get to taxes, but it has to do with property taxes.
Okay.
Okay. Now, for a document to be allowed in public records, it must meet state's law qualifications, of course. Some states require notarization, others just witnessed, and sometimes might also require the document's preparer's name. So if I prepared the deed or whatever we're filing, I have to write prepared by. State of New Jersey requires notarization and preparer's name in that document. As we advance in technology, this process has become easier. More and more electronic recording is becoming accepted as a valid way to record it. So now we just submit it online and it's done. Priority is the order in which documents or liens are recorded and affects the priority of interests or claims to the title. Right? Many situations can affect the rights to a property and the courts and how the courts rule in favor or against interested parties. As real estate professionals, we should be able to explain this, but legal questions should be referred to who? Legal counseling, attorneys. Okay? Just like everything. Somebody asks you a question about a mortgage, what do? Let's talk to a loan officer. Somebody asks you a question about an appraisal, what do? Let's talk to an appraiser. Somebody asks you a question about title, let's talk to a title or attorney. Okay? So we have to know it, but just to refer to the proper authority. Let's put it like that. Okay?
Does each
Cameras on, guys.
Does each brokerage have like this appraiser works for this brokerage?
No.
this-
What we do, that's a great question. What we do is have our team. So I have my preferred team of appraiser, home inspector, attorney, title company. That's my team. We recommend them to our agents, right? But they can use whoever they want. And in fact, an agent cannot force anybody on the client.
Right.
So I can say, hey, client, for you to work with me, you have to use this mortgage company. Nope, I cannot do that. What I can say is I got my team and the process might be smoother if we use the whole team. But if you have a preference, if you have your own attorney, if you have your own loan officer, whatever, I'll work with you. Just might take a little longer. And this is true because most people, buyers or sellers, they have that attorney that they've worked with in the past. But it's a litigation attorney because of a traffic ticket, because of a divorce, because of whatever. Litigation attorneys are not real estate attorneys. Can they do it? Yes. But they're used to court. And in courts, you file something and then you wait months. Okay, you file something, you wait months, and that's how they manage it. So the attorneys I work with, they specialize in real estate transactions. Okay, much like if you're going to go for a heart surgery, you're not going to talk to a brain surgeon, right? Two different type of specializations. You're not going to ask your general practice doctor to also perform the surgery either, right? So that's why when I talk to my clients, it's always, hey, I got my team, but it's your preference first. If you already have somebody, we'll go with them. If you would like to give them a try, I have all the referrals or recommendations you might need. Okay.
Maybe.
Clients do, yeah, you don't pay. Elizabeth says, I did the whole team and it worked so easy. There you go. Yep. All right. And sometimes it could be, by the way, sometimes it could be more expensive, the fees, but the fact that the whole process is smoother, you actually save money because you're saving time. I've seen transactions that just to get out of attorney review, I'll explain that better in a later time, but just to get out of attorney review, which should happen in less than a week, it took a month and a half. A month and a half is another mortgage payment. You're trying to skim a few bucks here and there, boom. You just lost $2,000 or $3,000 on the mortgage payment that you didn't have to. So those are things to consider. Unrecorded documents. Obviously, it's something that's not recorded into public records, right? Can something that's not recorded into public records affect my ownership? Affect my ownership or my interest or my claim?
Yes.
Yes? Maybe?
Yes.
Definitely?
Like
Okay.
marital status.
Marital status, for instance. What else?
Tax.
Taxes, real estate taxes. These are not recorded, but they're assumed or presumed to exist. Because we do pay taxes, right? Very good. If you don't pay taxes, what can happen? They can file a lien against your property, an automatic lien, and foreclose. Other unrecorded documents could be marriage certificates, could be child support, judgments, inheritance, and franchise taxes. Okay, these are not recorded in land records. They're public records, but they're not in land records, and they could affect your property. Carla, you good? This part you're good. Okay.
Yeah.
It's tough to come in
Yeah.
like after we started, yeah.
Yeah.
But anyway, I always go back to the beginning, give 3 examples here and there, so hopefully you'll catch up. Chain of title. If we see the word chain of title, the first thing we got to look at is chain. What is a chain?
Bunch of links together.
A bunch of links together. Correct, right? So if we're talking about chain of title, what do you think it is?
Title.
La-
The house. Everyone's
Louder.
on the property, like the
On
whole
the-
chain of the owners.
Okay, so not on the property because I could own and not be there. But yes. Ownership. It is to prove ownership. So the chain of title is what links the current owner to the previous owner to the one before that. Chain of title, right? So like a chain, the current title of a property must be linked to the previous owner, to the one before that, and so on, all the way to the first owner. We should be able to track who owned this property. You guys remember we talked about this yesterday? When we were talking about warranties, right? Or the different types of deed. Now, what if a link is missing? if we have a chain, like I got a chain on my neck right here, if a link was missing, what would happen?
Well,
It would fall, right? So there's a default, right? That means that we have a gap in the chain. If there's a gap in the chain, can we prove ownership? No, so we need to correct it. Okay. So if we have a faulty title because there's a gap in the chain, right? And if this gap exists, then we have a cloud on the title. If it's a cloud on the title, this is a type of. If there's a cloud on the title, it's a type of encumbrance. Encumbrance. So the fact that we cannot prove that the ownership is linked, it's also an encumbrance. Okay. How do we correct it? It could be a quit claim deed, absolutely. But if we cannot find the previous owner to help us resolve the issue, right? To establish the present ownership, a court action called action to quiet title must be filed. So we need to go in front of the judge and say, if we cannot get a quit claim deed from that particular owner, so we can correct the issue, right? We talked about it yesterday. Then we have to go in front of a judge and say, Your Honor, here's my proof. Here's everything I have that I did purchase the property. Please allow me to correct this. And it will be a court order by the judge. So it'll be a court deed or a sheriff deed, even depending on where you are, that will record that transfer from the previous owner to you again. Okay? It's called action to quiet title. Jefferson's asking, does that mean that the link will start with you or previous owner? No. We continue the link. It's not starting the link. See, the link ends with me. I'm the owner right now, Jefferson. I'm the owner, right? But I cannot prove ownership because there's a gap from the previous owner, right? There's something missing there. So it's either we go to the previous owner or the one before that, wherever the gap is, that's what we need to correct. Let's say it was 100 years ago, right? Between two owners, there's nothing on public records for some reason. Can we go find them? Probably not. So we need to ask the judge to correct or bridge that gap, right? That's the quiet title. Does that make sense?
Once there's that action quiet title, like once that's in place, there's no longer an encumbrance. Like that fixes it.
That fixes the encumbrance. So now I can sell the property
Got it.
because it shows that I have title. Correct, Jefferson. Yep. You guys were asking the same question. Yep. So, but that's what it is. That's why we either do a quit claim deed if we can find the previous owner. Remember, a quit claim deed has no interest, right? Or might have no interest. The previous owner no longer has an interest in the property, but he or she has to, or it, if it's a corporation, has to sign off that they transfer the property to us. Okay? All right. Title search and abstract of title. The title search examines public records for title defects. The current ownership records are examined to determine if there's a gap in the chain. Usually, the title search goes back to 60 years or some other definite period, depending on state statute. And when doing a title search, other public records are examined to determine if wills, court proceedings, or other encumbrances exist and may affect the title. We already covered this, right? Now, when you see the word abstract or the words abstract of title, this means a summary or brief history of the title search results. Okay. The only reason why I have it like this, I'm trying to get this book to answer all your state exam questions. In the state exam, these will be the three variations of the question. They'll either talk about an abstract of title, they'll talk about a summary of title, or a brief history of title. And either in the question or in the answers will be one of these words. So when you see abstract of title, look for the answer that talks about summary or brief history. When you see brief history in the question, look for the answer that says abstract of title or summary. All right. And that's so you guys know what I'm trying to accomplish with this book, to make it as simple as possible and give you all the possibilities for the exam. Okay. Yeah, cheat code, something like that. I wish I could create a book just with the questions and answers, right?
That'd be so good.
That would be so good, right?
So good.
I have them all, but I cannot give any. Yep. So I wrote the book around the questions. Let's see. You guys are the guinea pigs for this book, by the way. Yay. All right. An abstractor, that's the name of the person that searches public records and summarizes all the results found and places them in chronological order. So when they pull the title search for 60 years, they're going to say, hey, back 60 years ago on whatever date, this person purchased the property. 5 years later, this person purchased the property. So they put it all in chronological order. So it's easy to read, right? The report includes all recorded liens and encumbrances and their current status, as well as references to which public records were examined. Because remember, it's not just land records. Sometimes we need to pull from other records like taxes. Right? I need to go check the taxes and see what their status is. Are the taxes paid or not paid? Right?
So it gives like a works cited page, basically,
Hey, what?
like a works cited.
Uh-huh. Pretty much. Pretty much. All right. Next thing we have is marketable title. Question. What does this word mean? What is something that's marketable? Forget real estate. Something that's marketable. Sellable, buyable, exchangeable, right? A marketable title is a title that can go on the market, that could be sold, bought, or exchanged. Okay. Now, if there are issues with the title, as I said before, I had a lien against my property that I didn't even know. Can I transfer the property? Yeah, well, if the buyer accepts the property with a $16,000 lien, sure. Do you think the buyer is going to do that? Most buyers won't. Investors like me, yeah, I'll look for all the problems. I'll help you solve all your problems for a discount on your property, right? But most buyers want a marketable title, something that's free of any encumbrances, okay, or issues. So a real estate sales contract traditionally requires a seller to give the buyer a marketable title, and that is a title that is free from material defects and that will not subject the buyer to the risk of losing, of legal action or jeopardize their ability to enjoy the property. So marketable title, free of any issues. Is that good? Good so far? Thumbs up? Good. All right. All right, a title that doesn't meet these requirements can still be transferred. Like I told you, I can ask the buyer if they want to purchase and pay for that $16,000, right? But it may limit or restrict the ownership rights. Because if the lien is there and the buyer doesn't take care of it, they can lose the property. So it's at their own risk. A conveyance different from the one specified in the sales contract cannot be forced upon the buyer. So if you say that there are no issues, right, and then all of a sudden there is, we cannot force the buyer to buy. So let's say we're a month in, like it happened with my property, title search comes up, there's a lien. Can I force the buyer? No, I had to back out. I'm the one that lost time here and money. Although, once a buyer accepts the unmarketable deeds, the only legal remedy available will be under the warranty covenants, if any exists. Okay, so if I sold it to you with issues, you accepted with issues, then pretty much you have no way to come after me unless I give you some type of warranty. A preliminary title search right after an offer is accepted as customary, as well as a title contingency clause in the sales contract that allows the buyer to review and approve the title report before accepting to proceed. So we put an offer. This is the way it usually goes. We put an offer on the property. The seller accepts the offer, but the offers are contingent upon title search, home inspection, and mortgage approval. Those are the basic ones. There's more. We can put more restrictions, but these are the basic ones. We're going to inspect the property within X amount of days, right? We're going to pull a title search, and if title is clean, we'll buy it. That's contingency, conditions, right? So that's why we need to pull it as soon as possible so nobody wastes time. As soon as we under contract, once the buyer accepts it, as soon as the seller accepts it, we under contract, we should speed up the process, go straight for the inspection, straight for the title search, so then we can get the mortgage commitments. The mortgage company won't give you a commitment until these are cleared. Okay. All right, ownership proof or proof of ownership. Which document proves ownership? Which document proves ownership? Without reading. Title is not a document. We talked about this the other day.
Title insurance.
Title insurance is not a document, but not a document of transfer or anything like that. But we're going to go over that. I have title. I have deed.
Certificate of title.
Are you reading?
Oh, it's right. Oh, they're all right here, but I didn't.
Lawyer signature. Okay.
Certificate of title. I guess.
All right. So for those of you that said deeds alone do not prove ownership. A deed only proves that a sales sorry. Stephen, that was good. And a handful of dirt. So you weren't here, but I did mention that back in the day to transfer property, they would just grab dirt from the land and say, hey, this represents the whole land. Now it's yours. So Stephen just wrote, oh, and a handful of dirt. It proves ownership. Doesn't prove anything. It just proves, just like a deed, it proves that a transaction happened. He never proved that I could have transferred that dirt. Make sense? So proof of ownership is proof of marketability. The following types of evidence of title usually prove marketability. Certificate of title, attorney's opinion title, title insurance, torrent certificate. I was on the roll, I'm sorry. Because he said title and I went with that. Title insurance and torrent certificate. Okay, certificate of title, attorney's opinion title, title insurance, and torrent certificate. Do you see deed over here? No. Deed is part of title, but deed is not title. Okay, deed is part of title. Why? Because deed shows that the transfer happened. We're going to use one deed. We're going to go back and look at the other deed. We're going to go back and look at the other deed. And if everything shows the proper transfers, right? And there's no other issues in between when we do the title search, then the deed becomes part of the title. It's a good transfer. Attorney's opinion might as well have dirt. Yes, we're going to go to that too. So, certificate of title. It's an opinion of title's status on the issue date. It doesn't guarantee ownership. By the way, this is kind of like in order of strength. So this is like the weakest type of evidence of title. So it certifies the title condition based on title search. A title company, abstractor, or attorney can prepare the certificate, and the title certificate can be used as evidence of ownership, but you're right there. Evidence of ownership, but it's not perfect as public records do not show unrecorded liens or rights of parties in possession. So just searching for records alone is not enough. That's pretty much what we're saying. A certificate of title means we just search for records. That's it. So because forged documents, incorrect marital information, incompetent parties, minors, or fraud are undetectable. A certificate offers no protection against said defect. Okay? A preparer of this certificate can be liable for any negligence. So if they fail to show something that's on the title search, if they fail to put something there, they're liable for it. Now, attorney's opinion of title. In some areas of the country, an attorney's opinion of title based on an abstract is sufficient evidence of title. The attorney's opinion of title, like a certificate of title, does not protect against defects not found in public records. To protect against potential title defects, many buyers buy title insurance. So if you guys look at this order before we go to the next one, certificate of title is like we just did a title search and we certified that this is what we found. That's it. That's it. Attorney's opinion of title is we did the title search and the attorney is going to give his legal opinion based on what he or she saw, right? That's it. So there's in neither one of these, you'll find a guarantee or any type of protection. Okay? There's like you guys looking over here and saying, hey, this is blue, right? For everybody at home, this is white with letters, isn't it? What's over here where my hand is? Right here. White. But you guys see blue. So you are not seeing what they're seeing. That's the unrecorded documents. Does that make sense? All right. So it becomes just an opinion. From what I see, this is blue. From what they see, this is white and a bunch of letters. Because they see whatever is on your screens here. Right? So the best thing you can do in states where certificate of title and attorney opinions are issued, the best thing you can do for protection is to get title insurance. That's the third method of evidence of title. Why? Because a company is so sure of what they found that they're willing to insure it. Does that make sense? They're so sure of what they found that they're willing to insure it. All right, so as the name suggests, title insurance protects policyholders from title-related losses. Just like with the certificate of title and attorney's opinion of title, a search of public records is made. Once reviewed, the title insurance determines the property's title insurability, and if approved, a policy is issued. Unlike other types of insurance policies, the title insurance covers potential pre-existing events, and the title insurance company defends any lawsuit based on an insurable defect and pays the claim if title is defective. Just like happened with me. That $16,000 popped out of nowhere, right? They had to check the title. There was nothing there. This lien was related to a previous owner, so I'm covered. A preliminary title or title policy commitment report usually is issued, and it includes the name of the insured party, a legal description of the property, the estate or interest covered, the terms and conditions of the policy, and the list of all exceptions, including encumbrances, defects found in public records, as well as any known unrecorded defects. So what will happen is they do the search, they issue a report that says, hey, this is what we found. We're willing to insure this, but we're not insuring this. Usually like shared driveways. They do not insure claims on title for shared driveways. You're going to have to fight that on your own through surveys. Okay, title insurance does not fight it. Does that make sense? Okay. By the way, it says legal description of the property is included. What are the types of legal description?
Meets and bounds.
Meets and bounds.
Lot and blocks.
Lots and blocks.
Block and lots.
Yeah, lot and block or block and lot is fine.
Yeah.
You said lots.
And the rectangular government
Rectangular
Potato slash government.
survey system, yes, very good. So the types of legal description, meets and bounds, right, where the property lines meet and create boundaries. That little squarey one where we have a lot of trouble trying to figure it out, which is the government survey method or rectangular survey system. And we have the plat map or of subdivision, or also called lot and block method. Okay, legal description is included everywhere. Now, to answer your previous question, a single policy premium is paid at closing. We don't pay this type of insurance. We don't pay forever. We pay once at closing. You can purchase at any time, by the way, but it only insures from that day on. It does not insure anything that could have been recorded from when you purchased to the title policy, okay? And the policy face value usually is for the balance of the loan if it's a lender's title policy. This type of policy is the most common and usually required by a lender to protect its interests. So lenders, who purchased a home? Did you ever purchase a home? Okay, we have a few hands. Do you know what type of policy do you guys have? You have a lender's policy, you have an owner's policy. What type of policy do you have?
I would say renter's insurance, but
No, for at the purchase.
Oh.
The two people that said yes, so Connie and Zoraida, what's the answer? Elizabeth says owners, so you paid cash for it? No? So you have a mortgage policy. Or did you get an additional policy? See, here's the thing. When you're buying a property, I know there's a lot of documents that we sign at closing, a lot of them, right? But when you're buying a property, one of those documents is the mortgage title policy or lender's title policy. The lender, if you're financing, wants to be protected, that nobody can claim the property and they lose all the money they put up front for you. Okay, so they want to be protected. Now, attorneys, title company, and even realtors, us, we're supposed to tell the buyer, hey, Mr. and Mrs. Buyer, right? You have you have the right to purchase an additional policy for yourself. And sometimes it's just an additional $300. Like you already paid $3,000 for 10% of the cost, you can get your own policy.
what does that do for you?
It protects your interest. See, in the case of, we're gonna go over that too, but in the case of somebody disputing the title, saying, oh, no. This does not belong to Carla because it belonged to my granddaddy. My granddaddy transferred it to me. So now I'm here claiming the property and saying, you gotta go because this is my house, right? A title insurance policy will activate an attorney. They pay for everything. Activate an attorney to protect Carla's interests. You got it? They will step up and say, hey, no, Carla's the owner. We did the title search. You are nowhere to be found. The problem is not yours, not Carla's. And our attorneys are going to defend her at all costs. Now, if Carla does not have this policy, there's only a lender's policy. Guess who's protected?
Bank.
Just the bank. If I can prove that I have superior title, I take over your house because it's my house. Lender gets paid and you get to suck your thumb. Sorry. You got it? That's why you should always ask for the owner's policy. At closing is just an additional $300 or $400. Okay. All right, coverage. The type of policy determines which defects the title company will defend. A standard policy insures based on the information found on public records, and it also covers forged documents, incompetent grantors, incorrect marital statements, and improperly delivered deeds. The owner's title insurance policy, or also the lenders, will do something similar. Under the standard coverage, they cover defects found in public records, forged documents, incompetent grantors, incorrect marital statements, and improperly delivered deeds. If you have an extended coverage, it covers everything from the standard, obviously, plus defects discoverable through property inspection, including unrecorded rights of persons in possession. Who are the persons in possession?
Previous,
Well,
possible.
possibly, but who else? Who else can be in possession of the property that's not the owner? Louder. Tenants, for instance, they have rights, they cannot get kicked out. But who else? The bank does not have possession of the property, they have an interest, not an estate.
It's an equitable type,
Equitable title, yes,
not a,
monetary, not legal title,
not
correct. So, but who else can have rights to the property? Who can go there and plant flowers or maintain the property?
utility.
Utility companies are gonna plant flowers for you? They're gonna bring, let me turn on your electricity. Here's a pot for good luck. These flowers bloom amazingly. Yes. We got family, could be.
Heirs.
A realtor occupies the property? I don't know, these are Jefferson for the win, squatter, July for the win as well, squatters. Don't squatters have rights?
Adverse.
Adverse possession. Okay, so squatters, somebody could take over the property and now be able to claim a right to the property. Are we gonna find that on public records? Probably not. Okay, so the insurance company, birds and the bees, Zoraida, that was the previous Zoom. In this Zoom, we're talking about real estate. Birds and the bees was until 5 o'clock. Sorry. The second time that she keeps on going, and yet she said, "Your jokes." Okay. Examination of the survey, which is the location of the property. Unrecorded liens now known by the policyholder. What is not covered though? Neither of these policies cover defects and liens listed on the policy, so stuff that we know as an exclusion. Defects that the buyer knows. So if you knew that there was an issue, it does not cover. This is why we can't admit anything, okay? You know, Shaggy song, wasn't me. Have to deny. All right, so they can cover it. And changes in land brought about by zoning ordinances. So that's out of your control. City decides to change the zoning. Title company is not going to insure, oh, they changed the zoning, right? That's a government right. Title company won't insure a bad title or protect against title defects that can be discovered through title search. Policy exclusions list uninsurable losses like zoning ordinances, as I was just saying, restrictive covenants, easements, certain water rights, current taxes, and special assessments.
Before you pay for the title insurance, they'll tell you what's not protected, right?
Yeah, they'll issue a preliminary report. Remember, they give you that report that shows what they cover, like who you are at the insured party, right? The legal description of the property, what they cover, and what they exclude. Yeah. Not that people read, they just go like, oh, I got title insurance, great. Just like everything else. It's like when they sell that extended warranty on your car. Congratulations on buying your car. Would you like an extended warranty that covers absolutely nothing? We have the basic, right? The silver, no, the bronze, the silver, the gold. We even have a platinum. They still don't cover anything, but do you want it? Right? Who fell for that one? Anybody? Who has an extended warranty on their car? Nobody? Just me? Okay, there you go. Sure. Yeah, I fell for it.
And my car's extended warranty is expired. I mean.
Yeah,
All the time.
I fall for it every time. Doesn't matter where I buy the car. They're like, they always promise something. I'm like,
Maybe
fine.
this time.
Maybe this time we'll cover something. Encroachments. What is this word? We covered it already, so you should know.
Restriction.
Mhm.
Cloud.
Mhm. Well, it is a cloud. Because it's an encumbrance. But what type of cloud? What type of encumbrance?
Like a shared cloud.
Nope. Michelle for the win when it goes over the property line. Encroachment is an illegal extension over somebody else's property. Okay? You always think of interference? Football. No? But as it is, you're interfering with somebody else's, property. So encroachments or property improvements that violate zoning requirements, so like building setback requirements, for example, are also excluded from the coverage. Now, yesterday we mentioned twice the torrent system. Today we've mentioned it as well. We're going to finally cover what the torrent system is. There are only 11 states that use the torrents system. They include Colorado, Georgia, Hawaii, Illinois, Massachusetts, Minnesota, New York, North Carolina, Ohio, Virginia, and Washington State. New Jersey does not use the torrent system or torrent certificate. So in the state exam, you might have a question that says, which one of these is not used in New Jersey? There's 4 answers: certificate of title, we have the attorney's opinion of title, we have title insurance, and we have torrent system. Which one of these is not used in New Jersey? Torrents. Okay. The torrents registration provides title evidence without the need of a public record search. Under torrents, a property owner submits a written application to the county clerk, court clerk, to register the title. If the applicant proves ownership, the court orders the registrar of titles to register the real estate and issues a title certificate. The original title, torrent certificate title in the registrar's office shows that the landowner, all the mortgages, judgments, and similar liens. The torrents title system relies on the physical title document, and the person acquires title only when it's registered. So this document, it's one single document. When we have a title search, it's a brand new search for all the deeds that are registered in the public records. The torrent system is we keep on putting an attachment against those same documents. So it's not a new deed, it's not a new title, it's the same title, same everything, and we're just putting another line to it. Let's put it like that. Okay, so it's another line, all in that one document. Okay. But it's not used in New Jersey.